Okay, students, we're going to take a look at immigration reform since the 1980s with regards to neoliberalism and the Mexican problem. Now, the most vexing element for Congress in the 1970s and 80s was the issue of undocumented immigration. Historians write that it took over 13 years of congressional debates and political grandstanding to craft a response to the problem of prohibited migration. Now, the Immigration Reform and Control Act united diverse interests, but it did little to slow undocumented immigration. And it is the Immigration Reform and Control Act, known as IRCA, that was passed in 1986. And it took them 13 years to come to and craft a response to the problems of prohibited immigration or migration. Now, scholars have documented that the act penalized the knowing employment of the undocumented and established a new requirement that citizenship or work eligibility be proven upon starting a new job. And further, it gave permanent resident status to undocumented immigrants who had resided in the United States for at least 5 years and to undocumented immigrants with 90 days or more of work in perishable agriculture. And finally, the Immigration Reform and Control Act provided a means by which agricultural enterprises could recruit documented immigrants through the implementation of what are known as H-2A visas. This was the introduction of a modified form of the Bracero program. Now, although the act succeeded in legalizing the status of long-term undocumented immigrants already in the United States, in fact, those on the right today who revere Ronald Reagan as a god must appreciate that this Republican president took the bold step of offering amnesty to the undocumented. But nonetheless, the act succeeded in legalizing the status of long-term undocumented immigrants. It was unsuccessful, in discouraging new undocumented immigrants from migrating. Employers continued to knowingly hire undocumented immigrants. And as Baldemar Velasquez, who's president of the Farm Labor Organizing Committee today, so eloquently argues, that for every undocumented worker, there is an undocumented employer. Now, in part in response to pressures from the employer organizations, in part in response to pressures from chambers of commerce, the nation was unwilling and unable to enforce the employer sanctions of the act to this day. Some employers were fined, but very few have been jailed. And Congress drafted the law in such a way so as to offer employers an easy excuse. As long as they had no reason to believe that the documents that the new employees presented were false, they could not be prosecuted for employing the undocumented. So employer ignorance, as historians have found, led to a market of false documents, and it assured an underground network of cheap labor for business. And this has continued since 1986. Now, coupled with the desire to regulate the formation and control of labor forces in the United States were multinational corporations who wanted to usher in a new model of capitalist accumulation in the Western Hemisphere. So, as the United States and Western European and Asian Pacific firms searched for cheap labor and maximum profit during the border industrialization program of the 60s, 70s, and 80s, the maquiladora proved a valuable blueprint for expansion throughout Latin America. And as your readings have emphasized, the United States led a campaign for free trade. During the 1980s and 1990s, two new vocabulary words entered the foreign policy lexicon: neoliberalism and the Washington Consensus. So scholars have understood that neoliberalism and the Washington Consensus are strategies that are adopted by the International Monetary Fund, the World Bank, and the World Trade Organization. And U.S. foreign policy under the presidencies of George Bush the Sr. and Bill Clinton pressed developing nations, especially Mexico and Central America, to lower tariffs on imported goods and to create new export-oriented manufacturing zones, largely to serve the needs of multinational corporations. So neoliberalism, otherwise known as the Washington Consensus, through military prowess, coerced Latin American nations to massively sell off its public assets, to privatize its basic government services, and to submit national governments and financial and trade to the financial and trade dictates of the International Monetary Fund, the World Bank, and the World Trade Organization. So by the 1990s, the financial industries created a free trade model that was implemented here in North America, and it was sold to the American public as a solution to poverty, jobs, and immigration dilemmas, because the Immigration Reform and Control Act was coupled with the North American Free Trade Agreement. And the North American Free Trade Agreement promised prosperity for everyone. Canada, the United States, and Mexico entered into a permanent economic union that allowed multinational corporations to control Mexico's manufacturing, agricultural, and banking industries. But the neoliberalism in the guise of these free trade associations or agreements brought instead unprecedented social inequalities, the immiseration and displacements of tens, if not hundreds, of millions of popular classes throughout Latin America. NAFTA drove so many small Mexican manufacturers and farmers out of business that millions of people were dislocated and unemployment mushroomed. And this happened in the 1990s. Thus, instead of reducing the pressure on Mexicans to migrate to the United States, NAFTA, the North American Free Trade Agreement, instead increased it, okay? So let's appreciate that, because in response to the implementation of the NAFTA agreement in 1994, Mayan peoples from Chiapas, Mexico, coordinated a revolution on January 1st, 1994, and that revolution continues to this day. The NAFTA agreement included cancellation of Article 27 of Mexico's Constitution. And Article 27 of the Constitution is the cornerstone of Native peoples' resistance under the leadership of Emiliano Zapata against the government during the Mexican Revolution of 1910. So when we take a look at the Zapatista revolt of January 1st, 1994, and that continues to this day, Article 27 of the 1917 Constitution protected from sale or privatization native communal landholdings. So as you're seeing these images behind me, these are the Zapatista Army of National Liberation. It adopted the name of Zapata and his revolutionary stance and declared war on the Mexican state, labeling NAFTA as, quote unquote, a death sentence to all native communities of Mexico. And as James D. Nations states in Cultural Survival Quarterly, when the Zapatistas seized the public squares of the major towns of eastern Chiapas, they carried the symbolic banner of an ecological revolution. For despite its religious and ethnic overlays, the Zapatista revolt was essentially an ecological struggle, one that focused on two central questions: who controls the land, and what do they use it for? So let's take a look at Telesur's reflection on the 22 years of Zapatista resistance posted on YouTube this past January 9th of 2017. same time at the implementation of NAFTA and the Zapatista revolt, Californians reacted to Mexican immigrants through very racist methods. One of them was Proposition 187. It was also known as SOS, Save Our State Initiative. It was a 1994 ballot initiative to establish a state-run citizenship screening system, and it prohibited undocumented people of Mexican heritage labeled illegal aliens from using non-emergency health care, public education, and other services in the state of California. And after massive demonstrations, as you see the images here, the California Supreme Court ruled the proposition unconstitutional. And Kevin Drum, blogging for Mother Jones magazine on June 6th of last year, wrote and quoted from Keith Humphreys the following. Keith Humphreys points out today that California used to be a solidly Republican place, but then Republicans reacted to the state's growing non-white population by supporting the infamous Proposition 187. Like any Californian, I can attest to the venomous, racially divisive nature of the debate that surrounded it. Republican Pete Wilson publicly embraced the measure at every campaign stop and rode anti-immigrant sentiment to re-election with strong support from white voters. And in the process, Wilson and those who advised him to double down on white voters permanently crippled the Californian Republican Party. Subsequent Democratic presidential candidates have not even bothered to campaign in this minority-majority state. And why should they? The California lesson for the national GOP as party leaders debate whether or not to embrace Donald Trump: racially divisive appeals to alienated white workers can work, but pursuing such short-term electoral rewards is a route to long-term political oblivion in an increasingly diverse America. And so this was a response to what had happened in Proposition 187. So let's listen to what happened to the Republican Party in California by taking a look at Proposition 187 and the decline of the Republican Party.
In fact, she calls those of us who are in support of Proposition 187 racist immigrant bashers. I say we must end services to illegal immigrants.
More and more voices within the Latino community were saying, this is unfair. You know we work hard. You know we're not here to, suck up public services. We're here to work really hard.
My parents are illegal too, but I don't want my parents to leave.
No longer can California afford to educate, medicate, incarcerate, and compensate all the illegals of the world.
There's no better example of how the anti-immigrant tone in one election can inflict long-term damage on a party's image than what happened here in California after Republicans got behind Proposition 187 in the 1990s.
It's hard to imagine now, but Republicans actually won this state every presidential cycle from 1968 until 1988. Bill Clinton broke that winning streak in '92, but only in a three-way race with Ross Perot and George H.W. Bush.
1994 was kind of a crazy year in California. This is when OJ got in a white Bronco and went down the LA freeway. But other things were going on in California. The state had a very large crime problem. This is when the state passed the three strikes law.
The state was in the midst of a very deep recession in the early 1990s, in the aftermath of the end of the Cold War.
The military industry in California just took a whack. The aerospace industry in particular. California bled jobs, it bled revenue. It was a very rough place to be.
The Republican governor, Pete Wilson, who had been elected in 1990, a moderate Republican, pro-choice on abortion, was way behind in his re-election campaign because of the bad economy in California.
Illegal immigration started to come to the fore at that time, and Wilson, running for election, ran an ad called "They Keep Coming."
They keep coming. 2 million illegal immigrants in California. The federal government won't stop them at the border, yet requires us to pay billions to take care of them.
For Californians who work hard, pay taxes, and obey the laws.
And so a policy fight developed that very quickly became a political fight about whether the state should be cutting services for legal residents at the same time they were providing those services for undocumented residents.
So in 1994, Proposition 187 appeared on the November ballot in California. Proposition 187 proposed that public services be denied to illegal immigrants in California. This would be education, public school education, and health benefits for legal immigrants.
And because of the nature of the electorate in the early 90s, this turned out to be a lifesaver for Pete Wilson's campaign. That and the death penalty and the crime issue began to pull Pete Wilson from the abyss into having a chance of winning.
Wilson is ahead in the polls with less than 3 weeks to go.
Governor Wilson decided to get behind Prop 187, and many believed it saved his campaign.
The measure was approved almost 2-1, and Governor Pete Wilson signed the declaration that would deny more than 1.5 million illegal immigrants.
But that success came with a price.
And so there was this flurry, the synergy, which led us to be able to organize a lot more people to become citizens, to register to vote, and then eventually participate in more elections.
1 million new Latino voters entered the rolls in California. That is a peaceful revolution. It changed politics.
It took an entire generation of younger Californians to come of voting age, to express their opinions on an issue that had divided their parents and their grandparents. But for them, it was just simply a matter of common sense.
Republicans have struggled to win statewide offices, high and low, because there are 20 to 30 years of hard feelings pent up right now within Latino circles.
In 1994, when Pete Wilson was running for re-election as governor, registered Republicans actually made up 37% of the state's electorate. Today, they make up just 27.5% of the voters here and may soon be overtaken by Californians with no party preference.
The debate around Prop 187 galvanized Latino voters, making them a much stronger force in California politics. Latinos began seeking elected office in numbers that the state had not seen before.
So 1 out of every 5 Californians over the last 20 plus years, myself included, has now changed their opinion on this issue. The challenge is that the California Republican Party, and even to a greater degree the National Republican Party, hasn't kept up with that tremendous shift in public opinion.
It really took the federal court to overturn Prop 187. It was popular. But the state has changed since then, and the country has changed since then. But California became a blue state faster than it would have without Prop 187.
I mentioned the Stegner quote earlier, California is America, only more so. I like to say California is America, only faster. So the same type of demographic changes that have occurred here are now occurring in many other parts of the country. But the lesson for the National Republican Party should be a very stark one. The question is whether you're going to change with it.
Ironically, it is 2 national conservatives who aren't running for anything this year, Jack Kemp and Bill Bennett, who are going public with their opposition.
Use my statement to warn the Republican Party that at the moment it has the best chance in our lifetime of being a majority party. We must never, ever be perceived or in any way turn our back on people of color.
3 events occurred in the 1990s that are very important for us. They're going to lead to a very important act. It was the 1993 World Trade Center bombing, the initial popularity of anti-immigrant legislation and California's passage of Proposition 187 in 1994, and then the 1995 Oklahoma City bombing. Those 3 events are going to prompt Congress to restructure the United States immigration law in 1996. Now, the legislative changes were adopted in a rush atmosphere of fear of panic, an atmosphere of panic and fear under the Clinton administration. So President Clinton is going to sign the Illegal Immigration Reform and Immigrant Responsibility Act of 1996. IRERA. That's what I guess you could refer to it, IRERA. Now, this act overhauled immigration enforcement in the U.S. and it laid the groundwork for the massive deportation machine that exists today, where deportation is a constant and plausible threat to millions of people. Now, as reported by Dara Lind in Vox, more people became eligible for deportation in 1996. Legal immigrants, including green card holders, can be deported if they're convicted of certain crimes, which cover a broad umbrella of offenses, some of which aren't violent. But in 1996, Congress radically expanded which crimes made an immigrant eligible for deportation, in her words. Now, previously, immediate deportation was triggered only for offenses that could lead to 5 years or more in jail. So if you had been stopped and you were a green card holder, if you had an offense, and you were in jail for 5 years, you could be deported. But under this act, IRERA, minor offenses such as shoplifting made individuals eligible for deportation. So when this act, IRERA, was passed in 1996, it was applied retroactively to all those convicted of deportable offenses. So Dara Lind, again, emphasizes, in her words, it got easier to deport people. Immigrants convicted of crimes weren't the only ones stripped of the ability to argue their case before a judge before getting deported. Anyone apprehended within 100 miles of the border, and the act required the government to hold more immigrants in detention before deporting them, making it substantially harder for them to get lawyers. And I might add, providing an incentive for the prison industry to cash in on the fate of undocumented workers, because now the prison industry wants those monies from the federal government, and they want ICE to bring them prisoners. Now, deportees may be held in jail for months, even as much as 2 years, before being brought before an immigration board, at which defendants need to pay for their own legal representation. So let's listen to Don Kerwin of the Migration Policy Institute.
So what happened in the 1996 Immigration Act was that the categories of crimes for which people had to be detained, the mandatory detention provisions were expanded quite significantly. And the effect of that has been that, in 1994, 1995, we were detaining about 5,000 to 6,000 people a night. And right now we're detaining 34,000 people a night. So that's expanded drastically. A couple of things have happened in the courts. One is that the mandatory detention provisions, while removal proceedings are pending, have not been found to be unconstitutional. In other words, it's constitutional, but for the short period or the brief period during which removal proceedings are pending. That's one decision. A second set of decisions, however, involves indefinite detention, and that relates to people who have already been ordered removed. And under two cases, the Zydvitas case in 2001 and the Clark versus Martinez case in 2005, the Supreme Court has held that you can't indefinitely detain somebody after they've been ordered removed from the country. In 6 months after they've been ordered removed, the presumption arises that that person ought to be released. Now that presumption can be rebutted, but basically that's the point at which the government seriously has to consider the merits of that case in releasing the person.
Now, one final note with regards to the Immigrant or the Illegal Immigration Reform and Responsibility Act of 1996. There was a little section in it. It's known as Section 287G. This section is going to wreak havoc on the immigrant community. And it wreaks havoc on the immigrant community to this day. Very controversial section. IRERA addressed the relationship between the federal government and local governments. So Section 287G is part of the act that permits the U.S. Attorney General to enter into agreements with state and local law enforcement agencies, permitting designated officers to perform immigration law enforcement functions. And it was pursuant to a memorandum of agreement, and that's why it's called the 287G agreement. Called the 287G agreement, again, state and local law enforcement personnel are deputized to enforce immigration matters. So, whatever city, whatever county, whatever state, an administrator, if you are a racist, you can take advantage of this provision and you go after anyone who looks undocumented. And this set in motion the profiling that we're going to see that's going to take place in the late 1990s and throughout the 21st century. Okay, so I want to end this section at this time.